Good evening, everyone. Good evening. So glad to have everyone here for the first of the year. On 1/16/23, we're having our monthly meeting for SBREIA. Welcome, everyone. Well, we get started. The meeting's been called to order, and we get started with our prayer first. Can we all just bow our heads for prayer? Just, dear Heavenly Father, we come here with bowed heads and humble heart. We ask in your blessing, Heavenly Father, on this organization, SBREIA, moving forward. We pray for the leadership of the members as well as the membership. For in your holy word in Proverbs 4:7, written by King Solomon, wisdom is the principal thing, therefore get wisdom. But in all thy getting, get understanding. And all of God's people said, Amen. Amen. All right, now we will stand. We have to stand for the Pledge of Allegiance, please. We'll have a flag here. There she is right there. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Great, great. Now, are there any new members present? First-time members? I think we do. It's not a member, but it is a part of our associations, and that would be Mrs. Tammy Judge. Would you please stand and tell us a little bit about yourself, please?
Hello. Well, I'm Tammy. I'm going to be with the treasurer. I've been in Bossier for about 12 years and come from a military background, well, as far as my husband. So we've been in that military family. But I am just happy to be here. And if you need anything, just let me know. Anything I could do.
Thank you.
All right, thank you.
We just recently had some elections for SBREIA last week at our general board meeting, and I just would like to say that some of the people that were elected to the board, of course, Tammy just spoke. She will be our bookkeeper. Mrs. Dolores Smith will be the treasurer. Nancy was re-elected to secretary. I'll be serving as president, and Marcus will be serving as vice president. Also, we have board member Mrs. Pat Presley here. There she is back at the door. In addition, we have a new board member, and that will be Mrs. Virginia Vines. Hey, Jenny, how are you? Glad to have you on the board.
I'm glad to be on.
Outstanding, outstanding. Now, the next item is the secretary's report. And Ms. Nancy, whenever you feel pleasure, would you please give a report?
There are no minutes from the last meeting because it was the Christmas party at Shane's. It was a great event, and thank you for Dolores and her work to set that up. We appreciate it. We all had a good time. So there's no previous minutes, but the board did meet. Tommy did outline a few of the items that were discussed. We do have a new roster, and Tommy has very kindly agreed to move from Chairman Pro Tem to, and are you going to keep liaison too?
Yes.
Yes? Okay. So Tommy previously was our liaison for rental registry and for anything on the state side that affected landlords or our situations. And we do appreciate Tommy stepping up and being our president as well. We had some bills that we agreed to pay. We will be discussing some items for social media, and that will be for next meeting. And we did discuss some of the fees that were assessed from last year versus this year Tommy, do you want to go into that or do you want me to talk about it?
Just
The
briefly
fee?
mention what the fees
Okay,
are.
so this year, the fee will be $60 for new members, and that's an annual fee. Last year it was $120. We reduced that at the board level because we did not move ahead with our membership in the national SBREIA. So we just felt it was appropriate to reduce the fees to $60 this year. If anyone here wants to pay their membership fees, Tammy is the person back there who you can get with and pay your annual fee. The board did approve that anyone who paid the $120 last year, the membership last year, $120, and signs up this year for the new 2023 year will actually get a credit towards this year's membership. So if you know of anyone who isn't here tonight, encourage them to sign up again for 2023, and it'll be a very nice surprise not to have to pay. That's about it. We do have some upcoming speakers that Dolores is working on. We're looking at the eviction judge, Susan Waddell, for February. We're waiting for confirmation. Failing that, we'll have Maggie from Durant Title discussing the importance of 1031 exchanges. Pat, did you have comment?
No, that's
Okay.
good. She is going to be coming.
Okay.
She's going to be coming. I'm sure we'll get.
Okay, great, that's it. And there's no buy-seller trades.
Okay. Thanks, Madam Secretary, for that outstanding report. The next item on the agenda is the Treasury report.
Well, we don't have it up to date that much. This goes back to November, and we had 11,519.03. This was as November, but we do have some bills. We owe for the Shane's about $500 and something, and we owe a few other bills that we've got to pay, but we've got the treasurer and we're getting everything worked out to where we can do that. But we had 43 paid members last year.
Outstanding. Thank you, Madam Lewis, for that outstanding report. Now, the next item on the agenda is our member of the month. And our member of the month will be Mrs. Lemons.
Yeah, Trudy and Janet Lemon's mother and daughter. And they're going to tell us how they started in the rental business. Trudy has been a member for probably 25 years.
Is that very long?
Her and her husband used to come, but he died. So we're so glad to have you back. And thank you. You're welcome.
Sure.
Glad to be back.
Come on.
Let's get over here. Yeah.
Yeah.
Okay. Did you wanna, okay, start?
I'll go ahead and introduce my mom, Trudy Lemons. I am now helping her with her rental property, me and my sisters, but she consults, she's in a consulting capacity, well, more than that, she does a lot. She's still out there working with us and helping with everything and giving us advice. So I'll let her go ahead and tell you how she got into the rental business. Go ahead.
Okay. Well, like most of the people, they don't have lots of money. We didn't have lots of money either. We had enough to pay our bills, and we had a little bit extra for emergencies. And we had lived in Bossier in the subdivision there, the Swan Lake subdivision, and we had a 3-bedroom house, and we had 5 children. Oh, okay, thank you. Thank you. And as they gotten older, the house got smaller and smaller, and we decided to look for another house. So I think it took us about 5 or 6 months to never found anything that we really liked. So one time, okay, my husband had a co-worker that went out to lunch with him quite often. And at one time they went out to lunch and they took a different route. I don't know what reason or anything anymore, but anyway, they were going to buy a property that had a for sale sign on it. And Ken, that's my husband's name, Ken immediately said, we found the place, this is the place. And we went ahead and called the real estate agent, and then he told us how much it was, and it was a lots more than we could afford. But my husband wanted to look at it anyway, so we called him up, and he was glad to show it to us. And we looked around, we go out, and there was 2 driveways. One driveway led right to the house, and another driveway way to the back of the house. And we go out, and anyway, we talked, we looked at the place and kind of talked a little bit, and we got out back. And there I said, oh, how far does the property go? He said, oh, it's 2 acres, it goes way back. And there was 2 mobile homes on there. And there was also a cottage there. And he said, oh, you can afford it, this is rental property, it's yours too. And that's how we got into the rental. And then we had the house in Bossier, and they made 4 rentals. We bought the house, of course, because it was a big property, and we really liked the house, and we liked the location, we liked everything about it. So we went ahead and bought it, and we were still living there. And
You still live there now?
On Dixie Garden,
yeah,
yep.
on Dixie Garden. And of course, we don't have the renters anymore, but we're really lucky because real nice renters, real nice people. They didn't give us any trouble. They paid the rent. So that's the end of the story. That's how we got in. But then, well, there's more to it, of course. And then my husband worked for a company. He wanted to go on in business with himself anyway. So he worked for that company, and they downsized, and he got laid off. So we had a choice of either moving up north, we didn't want to do that, or transfer up north, and we didn't want to do that. And then we decided we're just going to, he takes the severance pay, quit, get laid off and get the severance pay. And then of course he had time now, and then we got into the rentals and worked the rentals, and there's a lot of stuff that he could do himself, and he did it. And so that kind of helped a lot, And we got now 22 units. That's it.
Yeah. Oh, yes, ma'am.
Trudy, what would you say not to do? What would you be your advice? Don't do this if you're in the rental business.
Well,
Not to let him go too far behind on the rent.
there's a whole list of what not to do. Yeah, I mean,
There's a lot of things, yeah.
but
And do you manage that yourself?
We manage it ourselves, yeah.
Good.
yeah, it's all in the family. My dad, but a big key to their success, my dad fixed computers for a living. And that was like, he worked for Unisys, and and the computers were huge then, big room size, and he would fix computers. And then that's why he was getting laid off, because things were changing in computers. So he, like Mom said, he wanted to be in business for himself. So they started purchasing more rental property. And also at that time, some of the reason they got really good deals, they didn't mortgage hardly any of the properties either. And a lot of them they got because the market had tanked, and it was the oil bust at that time. So some of them they've had for quite a while now. And so that's how they got further into it, by, just buying them with cash, really, and not putting loans on them. I see a lot of people lose their stuff because they yes, they're putting too much on credit. You kind of have to, I don't know, that's my opinion, but other people might see it completely different. But otherwise, my dad fixed so much. That was another key to how they were able to do it for so long, or still doing it, because he knew how to fix literally anything. He could fix plumbing, electric, everything. And he did so much of the work himself, so that's we miss him a lot.
What you do?
Did you want to say anything else?
No, I think I said it all.
That's great.
Thanks so much.
Okay.
Very nice. That is a very nice and interesting story. Thanks so much for Miss Trudy Lemons and Miss Janet Lemons. Got it. All right, now we're just about ready for our speaker. We have Mr. Lewis Smith come up and introduce our guest speaker for tonight.
We're glad to have Joe Gilsoul, and he has spoke to our group before, and he so graciously agrees to come this time, and we're glad to have him. We have on our printout all about Joe, but anyway, I'm so glad you came, Joe, and thank you.
I'm sort of glad you show I've been practicing for over 32 years. That's old. I need to update that on my website. Probably over 38, maybe 40 years now. Thank you. Yeah, I was a late bloomer. I didn't start law school until I was 34. Graduated at 37. It seems like forever ago now. For a long time I thought, I'm the oldest new attorney. Oh, I think I got some markers back there. Okay, this course is very, very informal. And stop and ask questions anytime you'd like. Make jokes anytime you'd like. Don't toss things, though. I don't have the reflexes I used to. No, I can still catch it, but I know it's coming. Don't normally start off talking about LLCs, but obviously that's something that's probably of interest to you. I imagine most of you do business in LLCs. There was a case came out a few years ago. One of the good things about an LLC is asset protection that it gives you personally as well as your properties. There was a case that came out a few years ago, maybe 4 or 5. Time flies, I don't recall. It was a Louisiana Supreme Court case. Astonished me. I realized I've been giving my clients wrong advice for many years, along with a lot of other attorneys too. The person who was sued was a builder. He was a young fella, small town. He basically built these homes by himself with as little assistance as possible. And he had an elderly lady friend who had known him all of his life, and she contracted with his LLC. He had an LLC to build her a house. So he thought he could do the foundation himself also. Of course, he botched it. Before the house was finished, the foundation was failing, tilting, cracking, all that. The house was a teardown. He didn't have the money to make it good. So she sued his LLC, and also she sued him personally because he was the one that did the bad deed, did the bad work. Because I can sue your LLC because it is your business, and I can sue you because you did it. And I'd always thought, well, yeah, okay, that's right, you're negligent. There's some personal negligence there. Well, the Louisiana Supreme Court said, no, he was not personally liable. I was astonished, but it made perfect sense. They said, if we hold him liable personally, then the statute is meaningless. Because it says personal liability will extend to, quote, professionals. I'm sure this was the first time that builder was happy not to be a professional, not to be called a professional. Probably was offended otherwise if anybody said he was not a professional. Excuse me. Professional is defined in legal parlance as somebody with an advanced degree like law, medicine, accounting, nursing, etc. That's a professional. A professional cannot be protected from malpractice by operating as an LLC. But somebody who is not classified as a, quote, professional can be, as that case made out. So I stopped telling my clients, look, if it's just you, don't bother using an LLC, you don't have any protection anyhow. I wish I could remember which ones I told that. And now I tell them, go ahead, do an LLC for no matter what you're going to do. Nice thing about an LLC is it has inside and outside protection. You know, some of you are pretty familiar with all this, but let me take you through it anyhow. That too small? Can you see that in the back? I don't see anybody nodding. Okay. Okay. All right. All right. And let's say it owns a rental property. That's a small rental property. That's a starter house, okay? And the house burns down because of some defect. Somebody's injured or killed. A huge multi-million-dollar judgment against the LLC, but not against you. That's called the inside out protection. The liability cannot go out to the owner. Well, I'm used to writing on a big whiteboard. Not that I'm that much more neat, but okay. So the liability cannot go out to the owner. Multi-million-dollar judgment, it's safe. Everything in that LLC is at risk. So if you have a whole bunch of little homes, maybe some of them big homes in there, maybe some automobiles and so forth, a bunch of cash, all of that can be lost because of one property that had a problem. You can lose it all. Won't come out to get your assets, your bank account, your investments, anything else, your home, but it will take everything within it. So I recommend it to people who really want to be totally safe. LLC, LLC, LLC for each one. I remember years ago, probably 10 years ago, I had a lady who had, I think it was like 32 properties. She was beginning the process of selling them off to retire, but it was going to take a while. I was explaining this to her. She said, well, I'm going to do 32 LLCs then. I said, man, that's going to be a lot of record keeping. She said, I already do the record keeping. I said, duh. Yeah, you already do it. So I quoted her a very generous price, just a regular fee for the first one, very low for all the rest of them. Almost killed us. I didn't realize how much work it would be to do over and over and over again, even though it was just basically changing the name, getting everything organized, getting it all signed, the staff working on it, all the things they had to do. So that's the inside-out protection. Outside in. You have a liability, nothing to do with your LLC. You're driving to get groceries. Drop your cell phone, you go to reach for it. Oops, wreck, your fault. And let's say there's a $10 million judgment against you. That sounds sort of ridiculous, $10 million? Well, it's not that hard to reach a very large judgment like that. If you hit somebody with good income, especially if they're young and have a long work history ahead of them, income doesn't have to be that great. You have a multi-million-dollar judgment against you if you destroy their ability to make a living. And your insurance, let's say there's $1 million liability, umbrella policy you have, they'll just come in and write a check for $1 million and provide you with an attorney. But that's it. The other $9 million in my hypothetical $10 million judgment, that's yours. You're going to have to pay it or go bankrupt. Well, this is where your debts have a very difficult time. A creditor is repulsed when he tries to get that to that LLC. For the most part. It gets quite complicated. I won't go into all the details on that. But basically a creditor can't just go in and take the stuff. his rights are to your property, which is your LLC, but it's limited. Now, if you had a corporation owning the property, they can get your stock. But the LLC, it's a little different. Can't go in and just dissolve your company and take the money out. Can't do it. It's protected against your creditors. Again, it gets complicated. If it's a single member LLC and you file bankruptcy, the bankruptcy trustee can actually step into your shoes financially and dissolve it. So they're just cash. So I encourage people not to have single member LLCs. It's nice because you don't have to file an extra tax return for that LLC. You just put it on your Schedule C, on your Schedule E, and on your personal 1040. But if you have a 2-member, 3-member LLC, it has to file a partnership tax return. So it's a little extra there. Many of my clients will set up an LLC and trying to be a little neater this time, a little bigger. Set up this LLC, and I encourage them to take, say they had 2 kids, 5% for each child, and give it to that child. Now they have a 3-member LLC. And if the documents are drafted properly, and state law does not provide this, if you just go download a form, you may not have this protection. The LLC, if done properly, will say it takes unanimous consent to dissolve. So, you're thrown into bankruptcy, some creditors force you in, or you just voluntarily go in, or they come after you just to try in a collection proceeding in a regular court case. You cannot be forced to dissolve this because you have 2 members who are going to vote against it. Pretty interesting. So what can a creditor do? A creditor can say, well, all right, I will seize whatever interest in this LLC I can get. The creditor can get what we call a charging order. That's just a judgment. The judge says, if you're going to distribute any money to the owners, instead distribute it to the creditor. So mom and dad's 90%. Don't distribute it to yourself, distribute it to that creditor. If and when you make a distribution. So you don't make a distribution. The creditor also cannot get into your books and records. Very strong. You just sit back and say nope. But they're going to find out how much profit you're making because you're going to give them a K-1 showing they have to put 90% of the profit on their income tax return. Because they are the people that have the right to get the income. Now with the partnership tax return, it doesn't matter if money is distributed, you have to pay the tax on it. You just can't leave it there and not pay tax on your personal tax return. Just like you have a bank account, it earns interest. You leave it with the bank, you still have to put it on your tax return, pay tax on that interest. Same way with this. If it turns out a profit, somebody's going to pay the tax. Well, we issue that K-1 to the creditor. So let's say it's $10,000, profit $9,000, K-1 to that creditor. I didn't believe that would work. And I don't follow LLCs nearly as closely as I used to, but I've not seen anything, there's been any litigation in that area. But you would think now logically, yeah, this is baloney. If this has to be distributed to the creditor, the profit has to be distributed to the creditor, that's to pay off my debt. So that's really for my benefit, it ought to go on my tax return. Apparently that's not the case. At least that's the story, that's the tack we take, and we're sticking to our story. So what happens, there's a lot of uncertainty in litigation with these things. So they settle. Everybody settles. I'm aware of one case shortly after LLCs came out where a friend of mine, any of you out there know Cody Mayo? Yeah, he's a very good attorney. And matter of fact, he was one of the people that hired me when I came in as a 37-year-old. He was younger than me. And, very creative, very good attorney. He had a client who set up with just cash and investments. And mother had set up one of these and put it in there for her 2 daughters. One of the daughters had to file bankruptcy. And the other sister came in and bid on that LLC interest. Now remember, you're a creditor. This is not a real attractive asset. You may not want this because you might get a 1099. You're going to have to try to collect money from this person. You don't want that creditor out there because you can't get your money out. You can't violate that judge's order to pay the money to the creditor. So you both want to settle. That particular case, the sister was able to buy her bankrupt sister's share for 15 cents on the dollar. Quite a very favorable settlement. So, again, I don't normally talk about LLCs in my talks, but because of the nature of your business, I think it's good information to have. Not everybody, of course, wants to set up one LLC for every piece of property. And when we first started doing that, the big problem was, well, what about the names? And I said, well, address, finally figured out this is easy. Address is located at 3734 Pacific Avenue. Let's call it 3734 Pacific LLC. Easy to keep track of them that way. In fact, I have one in Colorado. That's exactly what I call it. I think it's the address 3734 Pacific Avenue, LLC, Colorado LLC. Okay, let's get back into planning for people, for your future, for wills, trusts, things like that. For asset protection planning, one of the strongest things out, the strongest thing out there is a trust. Especially it wasn't your money that went into the trust. You put your own money into a trust, the creditor can go after it. The government can go after it. Taxman can go after it. If somebody else puts money into that trust for you, they can't get it. There was even a case in the Fifth Circuit Court of Appeals in New Orleans, federal court, back in 1999. There was a trust set up. Some parents had left their wayward son. His share of the inheritance was left in trust. He owed IRS a bunch of money. There was a corporate trustee, a bank was a trustee, and the bank, IRS just issued a levy to the bank. They don't have to sue. They just say, you owe us the money you didn't pay when you were supposed to. Therefore, anybody that holds anything that belongs to that person, they can force you to turn it over. So they issued a levy to the bank to try to get the money out of the trust. Here again, I had the wrong idea. And the law was stronger than I thought. I thought, well, that's IRS. Congress has given IRS different rules for debt collection. The normal rules that apply to creditors and debtors don't apply to IRS. They can get almost anything. If you live in Texas and you have that unlimited homestead exemption, that doesn't apply to IRS. They can take your home and sell it. So there's just a few things that IRS can't get. But so I thought, well, that guy's sunk. Yeah. The Fifth Circuit Court of Appeals said, oh no. It's true. The federal government cannot change state property law. Can't define what property is in a particular state. And so, what is a trust? What kind of property? What is that property right? What is it? What does it entail? Is this something that is capable of being seized by IRS? And the court said no. Because the way the trust was drafted, which is the way I draft all of mine, of course, the trustee had the discretion to distribute or not distribute. Could say, no, I'm not going to give you the money. Sometimes we say we're $15,000 a month, for example, unless the trustee has serious and demonstrable reasons to withhold. So we give the trustee discretion. Sometimes we just say the trustee can just do whatever they want. That's a family situation usually. So the court said, well, what is that right in a trust that this person has, this taxpayer has? It's sort of like, this is not what they said, but this is my interpretation of it. It's like grabbing smoke. You grab it in your hand, you open up your hand, there's nothing there. It's this thing out in the ether. Remember when they used to call air ether? Well, your grandparents would remember, that was older than any of us. But it's this intangible thing that the beneficiary can't really do anything with except receive benefit when the trustee decides to give it to him. So, IRS was not allowed to seize that interest in the trust. I really, really, really wanted to know what happened after that. I suspect what happened was there was a settlement. Because that guy did not want IRS hounding him for the rest of his life. And they would have been really watching this trust carefully, everything, to see if the money came out, and then grab it when it was out. And IRS wanted their money. They didn't want to keep working with this guy all the time. So I would imagine that it was settled. Paid some reasonable part of the tax for some reasonable amount of money. That's how strong a trust can be. And if the trust is drafted carefully, no. So let's say that my parents had left me a lot of money in trust. They didn't, by the way. They left me a little bit and I spent it real quick. I was rather young, and it was gone quickly. That trip to Disney World was nice. The kid, our son, enjoyed it. That was well spent. The ceiling fans were okay. There wasn't much more than that. But let's say they'd left a lot, and they left it in trust. Now, I had a car wreck. This $10 million judgment. Can't touch the trust. Had my parents left that directly to me, bye-bye inheritance. It's gone. And people think, well, if I got $1 million, I need $1 million of insurance. I got that. No, like I said, that judgment could be $10 million. Insurance paid $1 million, leaves $9 million. There was even a guy, I can't remember his name, back 20 years ago or so, wrote books. Thought he was a genius. He wrote books that were very popular. And that was one of the things he said. Figure out your assets and get liability insurance to cover that. It was terrible advice. He didn't think judgment could be bigger. Now, if they take my own money, they want to put it into a trust. So let's back up a little bit. What is a trust? They're strange things. It is just what we call a legal fiction. So is an LLC, so is a corporation. There's really no such thing. The legislature just passed laws about it. It's what they say it is. And the laws determine what the rights are for you and for everybody else. What all the governance laws are, everything. It's just made up. But it has very strong effect because it's binding on everybody. So a trust is a situation where one person administers property that belongs to somebody else. Now, you can't have a trust where you're the trustee for your own property. We'll get into that maybe a little bit later. But this hypothetical trust with all this millions that my parents, I wish, could have left me, I'd be totally free from any creditor, totally protected, if it was drafted properly. If it's not drafted properly, I'm in a jam. Could still lose it. Now, for most people, you're not going to have a car wreck where you're going to have a big judgment. It can happen, though. Sort of like that unloaded gun. There's no such thing as an unloaded gun, right? We always treat every gun like it's loaded. You don't point it at anybody, not clicking at people to scare them. Because once out of 1,000,000 times or so, that gun is loaded. As that bullet somehow got in there. Look at who was this actor that accidentally killed that girl on the set. I forget who it was now. But that...
Alex, what's his name?
Yeah, Alex Waldman, yeah. That was a so-called unloaded gun. They thought it was blanks. Didn't think it was a real gun even. Well, that's what happens when you're so sure of yourself. So that can happen. But something that's much more likely to happen to each of us, if we live long enough, is nursing home care. Might end up in a nursing home. Currently, the monthly fee, there's about a 50% chance any particular person, last time I checked anyhow, about a 50% chance any person will end up in a nursing home. And the average stay, last time I checked, probably old out-of-date figures, was over 2 years. But some people stay there for many years. A lot of my planning now is helping people qualify for Medicaid so they don't lose everything, lose all of their assets. Like just pay down. If you're a single person, you only have $2,000 of assets. Everything else you have to pay your own way. That's not counting one car. Doesn't count your house. Doesn't count the furniture in the house. There are a few things that are exempt. So we have clients that will go out and buy a $60,000 car. Can't drive? Well, the kid can drive it for you. $60,000, $70,000 car. That's not that unusual now. But basically everything else down to $2,000. Years ago, I keep saying years ago a lot more often than I used to. It used to be a couple of years ago or something. That was years ago. A lady came to me. This was about 5 years ago, not so long. Just a blink of an eye. Right? 5 years, blink of an eye. She was in her 80s, which is not that old anymore. I used to think it was pretty old. Now it's not so old. But she was in her 80s, and she was in very poor health. She had only about $720 a month Social Security benefit. Nursing home fee at that time was only $5,500 a month. Now it's over $6,000 a month in the decent ones. So she could not pay her own way. So she passed that income test. The income test, by the way, in a nursing home is, what does it cost to pay? If your income is more than that, you just pay your income. If it's less, Medicaid will pay the difference. So I have $5,000 income a month, let's say $4,000 a month. Social Security, $4,000 a month. I have to kick $4,000 a month over to the nursing home. Medicaid will pay the other two, $2,500, whatever it is. But there's an asset test too, that $2,000 I was talking about. She had inherited a piece of property from her parents maybe 50 years before, 30, 40 years, something like that. A long time in the past. Some country property, 1/4 interest. She had 3 siblings, they were all alive, all 4 children were alive. They were all paycheck to paycheck, pretty much in her financial condition. Very little money. One of them actually lived on that property, on, quote, her part. They'd never subdivided it, never partitioned it. But that piece of property had some value, because it was like, I think, about 100 acres or so. So many thousands of dollars. That property was way over $2,000. Well, if she sold it, then she would have cash of over $2,000. And we could have done something to save about half of that cash. But she couldn't sell it. Why couldn't she sell it? Well, the family didn't want anybody else owning that property with them. They didn't want to partition it, and she just sold her 1/4. Now, if she just sold her undivided interest, then there'd be a new co-owner that could actually go on the land. Dolores, if you and I, if you're foolish enough to buy a piece of property with me, and we're both co-owners, I can go on that property anytime I want, use it, leaving if I'm up to no good, leaving a mess, beer bottles strewn all over the place, stuff like that. I don't do that, but just to make a point. People don't like co-owners, so they would not want a co-owner. They would have had to partition the property first, but then they couldn't afford to pay for a surveyor to come out and partition it. Would have taken time, and they really did not want to sell any of it. I've never heard back from that lady. I suspect that the family just took her home again and did the best they could. I don't believe she was going to live much longer. Her health was very poor. So, but had her parents left her share of that, left all that property in trust for the 4 children. The children could have been the trustees. You don't have to go get somebody else to be a trustee. It doesn't have to be a bank. I know when I was young and somebody said trust, I thought of a banker downtown sitting behind a big desk with a 3-piece suit on, like bankers used to dress. Now they have short sleeve shirts and very casual, which is fine. But that's not what a trust is. A trust is that relationship, and the great majority of the trusts I draft don't have a banker as a trustee. No corporate trustee. It's just family members. A lot of times they're co-trustees. They could have had that, and her inheritance would have been safe, would not have been accountable for Medicaid purposes. Another client I had several years ago, he was actually a retired judge. Katrina hurricane had chased him up out of New Orleans up to here. He was in his early 70s, had alcohol-induced dementia, I was told. Quite a character. Likable guy in a way, infuriating sometimes. But his dad realized when this kid was young, this man was a young kid, that he was going to be a problem and was probably going to be irresponsible with his money. So he let his 2 sisters have theirs outright, but back in the 1950s, his will was drafted. Left it in a trust with the bank as the trustee. So when he came to us, we were hired to sort of overlook his care. We weren't caretakers, but we overlooked his care. Had a staff member, that's exactly what her purpose was, to help people like that and get involved in their daily activities, whatever. Resolve issues at nursing homes and so forth. He went into assisted living here, and he was a handful. I won't tell you some of the things he did, but he thought he was a good fighter still. Picked a fight with somebody one time and got a black eye because he had no reflexes anymore, no strength anymore. He was a good-looking fellow. I mean, he's tall, slim, lanky, good-looking guys for his age. And he discovered very quickly, and he had allowance he was given. Well, for one thing, he had his retirement that wasn't involved in the trust. He just got his retirement outright. And the trustees allowed him to have an allowance. So he discovered very quickly that if he got somebody to drive him to the boats, and he flashed some cash, guess why he was doing that? He was attracting young 50-somethings. And boy, they were there looking for him. I used to joke, this man, sort of a hero of mine, he showed me there's hope. My wife said, don't tell people that. But had he not had that trust, his money would have been long gone, and he would have been in a nursing home. He was able to stay in that assisted living facility because of that trust money. We were able to hire 24-hour caretakers for him to make sure he didn't misbehave, to redirect him when he started to do something. Started to get too fresh with one of the staff, started to get extremely vulgar like he tended to get. Pick a fight with somebody, they were there to redirect him. That was their condition for letting him stay in assisted living, because he had all that money there to pay for assisted living, which is not covered by Medicaid. He had had to go off to a nursing home. He had been absolutely miserable. He had dementia, but he was well aware and smart enough that he'd hated that. He wouldn't have done well. He needed much more freedom than that allowed. It's funny when the nursing home manager, fairly attractive lady, in her 50s, 40s, something like that, we told her that he said that she secretly wanted to be with him, but she just couldn't hurt her husband. And she goes, so he was proud. But that's his personality. The trust saved him from himself. From himself. So I'm going to put my will up here, my estate plan on the board here. I think I'll be able to draw a little better. I'm facing the door, by the way. This is my so-called probate estate. Some cash, the house, car, stuff like that. Husband and I own half. My wife owns one half. And in my will, I don't leave it to my wife. Remember, she owns half of everything, so when I die, her half is hers. But my will says I'm leaving to my wife just the stuff. That's household furniture, the cars, the stuff. My half of the house, goes into a trust in my will. I wish that would switch to the whiteboard. That's terrible. Can't erase on this. Now, the income from this, the trustee of this trust, of course, is my wife. Any income it generates goes to her unless there's a good reason not to give it to her. The principal belongs to our two sons. But she has something called the right of invasion. If she runs through her own money, spends it all, and her income is not enough, then she has the right to start taking cash out of this trust on an as-needed basis, invade it. Take principal or corpus out. Not just stuck with the income only. That's one way to do it. Some people do it different ways. It gets to be a little complicated if they have children from different marriages. If they don't share the children, then it gets a little complicated. Because if the husband dies first and sets up a trust like this, the wife is spending her half first. And every time she spends something, there's less for her kids. His kids are happy about that. She's really upset about that. Although she'd died first, her kids would have been happy. So that gets to be complicated. And sometimes people jump through hoops and try to take care of that problem. But why did I do that? Why are we going to do that? And most of my clients end up going this same direction. My death, my half goes into this trust. Asset protection planning for that half. Creditors can't get to it like we discussed. The more likely thing, though, is Medicaid. One day she may need to enter a nursing home. We all say we're not going to do it. Kids say we're never going to put mom in a nursing home. Sometimes there's one sitting down at the end says, I don't know about that, but there's always going to be, usually there's going to be somebody who really does not want to put mom in the nursing home. Mom doesn't want to go. Majority of the time, some people don't mind. So by leaving this in this trust in my will, this is protected from that Medicaid. Now she needs to go into a nursing home, and she still has some significant assets. We can do a lot to save about half of them. So we save about 3/4 of the estate. Half of it in this trust, the other half she invests in. We do other things with it. I won't get into all the details of Medicaid planning. It's quite complicated. If I just left it to her, like most people do, we call these loving wills, leave it to each other. Often that doesn't work out too well, because now Medicaid says every bit of this counts. The car wreck, the creditor gets all of it. Dolores, it's about the time I met you, shortly after I moved to Shreveport. But you know, we've known each other for a long time. One of the first people I met was Dolores on the Homeowners Association out in West Shreveport. Yeah. There was a lady who pulled out of Spring Lake onto Line Avenue, right into the path of a young mother, Christmas Eve or somewhere around there. She'd gone out to buy candles to put on the table. She had ready to go for her 2 little daughters and husband. She was killed instantly. The poor lady that had pulled out was a fine lady. It was just a total accident. Probably, you know how that pillar on your car can sometimes block a car? You look, and they're behind the pillar. Somehow you look again, and they're still behind that pillar for some reason. I don't understand it, but it works that way, because I've almost gotten into trouble myself that way. I've learned to be real cautious about that darn pillar. I'm guessing that's what happened. Nobody was texting back in those days. So it was just tragic. Her first husband had died and left her everything. She had remarried, so she had several $100,000 she inherited from him. And I don't know, some of that might have been, probably half of that was hers anyhow. But she lost every penny of it. The insurance company paid $300,000, which is what her insurance was. And they just wrote a check. And I talked with the attorney that had sued her. They represented the family, those 2 little girls. And he said it wouldn't have mattered if she'd have had a couple of million, we'd have got it all anyhow. Of course, 2 small children losing their mother, it's going to be a huge judgment. They'd have gone all the way through to court, through trial. So they just took everything. So you had to just write checks. They wouldn't agree to let her keep anything. It was just a tragedy. Tragedy that the children, that the mother was killed, but also a tragedy that her financial security was wiped out, which she and her husband had worked for all their lives. Her first husband, all their lives, gone. No chance to settle. This would have prevented that. And then there's another thing. Don't see too many married couples in here. Are you 2 married? No, okay, no married couples in here. Oh, you 2 are married. Okay. Well, we can have a little bit of fun then. Ma'am, you die first. Normally I'd knock the husband off first. Okay, a little bit chivalrous. This time you die first. You have a will, leaves everything to your husband. Now he's sort of young. Appears to be a good looking guy, unless it's just that I need glasses, but appears to be a nice enough looking guy. How long do you think it'd be before he remarried?
Never.
The funny.
You would never do the same.
You made his life hell. You made his life. Yeah. Some people, some men don't. Usually guys usually remarry. Guys almost always, they usually remarry. Women have more sense. Guys are driven by different motivations. So the best answer, I get the best lines from my clients. The best line I ever got was, she said, "Why, hell, he'd bring his date to my funeral." And I did have a client who, when she died, her husband at the funeral was trying to pick up some of the more attractive ladies coming through the line, saying how he really could use some help. You'd think they could drop by him, cook for him and spend some time with him and stuff. It was astonishing. Just terrible. And I have seen where I once had a lady visit me. She didn't do a will, but she asked what would happen if she died without a will. And apparently she was happy with that. I didn't realize she was actually dying. And she knew her husband was running around on her, and she knew what would happen as soon as she passed away. So she died without a will. And he right away married his girlfriend. Has anybody heard of the term usufruct? Okay. When you die without a will, your children, if it's community property, your children inherit the property, but the spouse has usufruct. That's the right to the income and use of the property until the usufruct terminates, which is when they die, of course, then it belongs to the kids. Or if the spouse remarries, usufruct is done. So he, not having checked with a lawyer about any of this, he remarried right away. In fact, he took her wedding ring and redid it to give her a ring, which really infuriated his boys. Yeah. Boy, so the kids got it right away. I handled his succession, and he expected the boys to let him have everything. And they said, no way. Nope, Dad. So he was stuck. So that's a very good way to protect assets, is the use of a trust. What about a living trust? You've heard of those, huh? Avoid probate, the perils, the costs of probate, all that stuff. How are we doing on time?
Pretty good so far.
Okay, good.
7:33.
Okay, good.
Question real quick.
Yes.
Revocable living trust or irrevocable?
Revocable. Normally when people say living trust, they mean a revocable one.
Revocable.
Technically, there's an irrevocable living trust, but we never call those irrevocable. We just call those inter vivos, or irrevocable, irrevocable.
Are there any advantages with one versus the other for people who own real estate and have real estate in one of those vehicles?
Yes, if you own real estate and put it into an irrevocable trust of which you are a beneficiary,
Right.
creditor can get it. Doesn't help you at all. Somebody else has to put it in a trust for you. You have to inherit it from your parents or from your spouse, whatever. But, so that's an exception. There are a few states that allow protection for what we call that a self-settled trust. You set it up for yourself. And there's some of these island countries, like the Cook Islands especially, and a few of the others, legitimate, not tax havens, but legitimate offshore trusts can be done where they have much different laws and your own assets can be protected, even from the U.S. government. Way too complicated to get into here. But there are some exceptions, but they don't apply here. A typical living trust is revocable. That means you can go change it anytime you want. You set it up, you change it. And people do that sometimes. They get mad at a kid, they rewrite it to leave that kid out. The person they want to serve as executor or trustee of that trust, say, oh, my sister Susie is suddenly wrapped up with this crazy guy he's going to try to get the money. He's going to try to have her steal the money from the trust. I can't trust her anymore. He goes to him. So they could go in and change it. You can take everything out of it if you want to, just totally do away with the trust. The benefit of that is supposed to be you can avoid a succession, probate. Now think of it this way, when you die, you have assets in your name. I told you about my house. I got this house in my name, my wife and I. If I die, how do we get somebody else's name on it? That's not automatic. My wife can't just go tell people, now it's in this trust or it's in my name or whatever. There has to be a judgment signed by a judge that says who the new owner is. That's the probate or succession process. My will would be filed at the courthouse, along with a bunch of paperwork. Eventually there'd be a, quote, judgment of possession. That's like a deed. It has to be filed in the deed records, the conveyances. It shows the new owner of my half of the house would be my testamentary trust. Testamentary meaning part of my testament, my last will and testament. So that's the whole reason you need a succession. Well, what if I died and instead my house is in the name of a living trust? It's not in my name. We don't have to. The judge doesn't have to sign anything to change the name of the owner. I already did it myself while I was alive. But you can probably tell I don't have a living trust. That's how fond I am of them. That's how beneficial I think they are. I can do it for free. I don't have to pay some attorney a bunch of money to do it. I can just do it myself. I don't care for it. It used to be one of the big advantages was privacy. Because nothing is filed at the courthouse, the inventory, therefore, is not filed. If you go through succession, there's an inventory has to be prepared and filed. But now, that inventory, a detailed descriptive list is what we call it, can be filed under, sorry, I use this all the time, just under seal with the court. That means, I don't know where they put it, I need to go down there sometime and find out where they're hiding these things, but it's not where the public can get to it. It's some records, they have a separate set of records that are not revealed to the public. So now, any succession procedure You can file a motion that the judge ordered, filed under seal, the inventory be sealed, and nobody will see it. You go online and look for it, it won't be there. So you have the privacy if you want it. Most of my clients really don't care. The real big problem with a living trust okay, let's change this. Now let's call this a living trust. I own half of it, my wife owns half of it, okay? This one I did was a testamentary trust in my will. Different. Now I'm saying I put everything into a living trust. And then I die. My half of that trust splits off into a real trust. This has substance now. It's not revocable anymore. It's a real trust. All these rules about trusts apply to it. But that's not as good as a testamentary trust when it comes to Medicaid. Why not? They're both, even the verbiage is pretty much the same. For the most part, they have exactly the same language in it. The so-called, quote, boilerplate. It's the same in every document. You know, investment powers, ability to sell real estate, trade real estate, stuff like that. All of that is the same in every trust document. Doesn't matter how the trust is created, where it comes from. So these are exactly the same. Really, a living trust, when a person dies, is a will substitute. So why is there a disadvantage? Remember I told you when my will, Medicaid can't count this? If it's a living trust, they can count it. For up to 5 years after my death, they counted it against my wife for Medicaid purposes. Why is that? I don't know. The exemption for donations to a spouse includes a trust in a will. They have that language in there, very close to that. A trust in a will. Not a trust that already exists, not an inter vivos trust. Entered during vivos life, made while you're alive. Not an inter vivos trust. Just a testamentary trust is exempt for Medicaid purposes, not the living trust. I am not sure how up to speed Louisiana Medicaid is on that, how they treat these. I don't have the nerve to call them and ask them, because if they're not aware of this real clear provision, I don't want to be the one to spill the beans. And there might be a couple of old living trusts I've done that are still out there. You know, back before I learned this, I've known it for quite a while, but I didn't start off knowing everything I know now, of course. So but I'm pretty sure that they probably know that this is the case. And if there's a living trust, they're going to, quote, bust the trust. I feel pretty sure. And there was something I saw in the Medicaid eligibility manual that sort of gave that indication. It's that the Medicaid eligibility manual is written for Medicaid workers. So you and I had trouble understanding a lot of it. What are they talking about here? What's this? Refer to some other section that has nothing to do with anything we'd be interested in and so forth. But there was something in there that gave me the idea they're aware of that problem with the living trust. And if they're not now, well, there might soon be. I remember when I was a young IRS auditor, by the way, my first job out of college was working with the General Accounting Office, now called the Government Accountability Office. Then I worked with IRS for 6.5 years. And two things I really learned. Number one was I, like many people, like most of us, confused my opinion with facts. I just knew what the tax law was about this or that until some smart tax attorney or CPA showed me otherwise. And well, that's not what the law says. Okay. Things that I just knew were true. And you see that on the internet all the time. People arguing. They just know this, they know that. Facts don't matter. We're all like that to some extent. Some extent or the other, every one of us. The second thing I learned was I really got a big kick out of surprising that was something they thought nobody in IRS would know about. And sometimes we all knew about it, sometimes it was something I just went and hit the books for because I wanted to do a good job. I even work overtime sometimes just to learn the concepts. And it would sometimes surprise the CPAs or the tax attorneys and have a big adjustment that they never thought would be caught. Not, they weren't breaking the law, they were really breaking the law. And they get caught. Well, same thing with the Medicaid workers. We think just because they don't do something the right way now, doesn't mean it's always going to be that way. So I advise my clients about living trusts, and in cases like mine, and many of us don't do it, because it will not give any protection for the spouse. That's for married people, of course. If you're not married, you don't have that problem. Let's see, there was another point I was going to make here. Tell you where a living trust really shines. Really shines. I do these on a fairly regular basis. We should all keep this in mind. And I think maybe, I don't know if we had the handout, I think, I told them to put it in the handout material, I don't know. It's an article, Who Will Protect Your Child from You? Is that in there?
I don't think so.
Okay.
Betrayal? Inactive betrayal?
No, that was the wife leaving everything to the husband and went to the new wife and the kids didn't get in. Okay. Anyhow, this was actually written for a magazine called, I forget what it was called, years ago. I wrote this article. It's for special needs things, people with special needs children. And it's also been published by the Special Needs Alliance on what we call The Voice. That's just an online thing that talks about special needs, both for adults and children, and planning. But it's basically this. I realized that a lot of times the person who's in charge of all this, the trustee, mom or dad, begin to lose their confidence when they get older. I once did estate planning for a retired Air Force major, solid guy. He had a daughter. His wife had died and left everything to him. I handled her succession. Left everything to him. And he wrote a will, leave everything to his daughter. The client that referred him to me, somewhat of a friend of mine, she's a friend of mine. She called me a few years later and said, Joe, Major so-and-so, I'm so worried about him. He started walking in Pierre Bossier Mall, and he's met a girlfriend. And he's telling everybody he's going to change his will and leave everything to her. You can't let him do that. I said, I can't stop him. He can do what he can. So he was going to go leave it all to her. Not long after that, a banker came to me with an elderly gentleman who was slow, let's say, wonderful guy. I really liked him. Polite, sweet, wouldn't hurt a fly. His wife was a very strong, domineering type of person. The only relatives were her nieces and nephews, who were actually, most of them were criminals. One had even served time in Angola. That's how bad some of these people were. She kept them under control. They were afraid of her, just the personality. Well, she died. And now here was this, and left everything to her husband. So here's this poor guy with a substantial amount of money, living in a real, that house wasn't as big as this room even. It was a rundown shack almost in a poor part of Bossier City, but that was home for him. That's where they had lived. One of the reasons they had all this money. They lived well below their means. And the banker came in. She was all upset because she knew what was going to happen. They were going to get with him and going to get him to turn over his money. They were going to rob him blind. Nothing anybody would have been able to do about it. You call Adult Protective Services. They really can't do anything unless the man is declared incompetent. And he was not incompetent. He was just easily manipulated. And he was quite fragile in his old age. He was afraid of these people. Dawned on me, well, let's set up a revocable trust and put all his assets into it. Thinking of protecting him not from anybody else, but from those kids. The oldest one was like 44, something like that. Adults, really. And the bank would be the trustee, And he'd have, because it's a revocable trust, he could amend it anytime he wanted to, but, so let's say this, he can only amend it if the bank says he can. The bank are going to call you a gatekeeper. Somebody wants to get into this trust, they got to get past that gatekeeper. You can Google that term, I don't think you'll find it, I just made it up, because it seemed to fit. I like the term, my clients like it. So I call this a gatekeeper trust. So we set this up. The bank had to allow him to change the trust anytime he wanted to, as long as he was competent, and nobody was pushing his buttons. Yeah, we did that. And guess what happened? They showed up. And especially this 44-year-old not long out of prison was quite upset, because he knew he could have got it all. He was the dominant force in this family, just because he was such a dangerous person. He went to various banks went to that bank to try to get money out, one of the branches. They actually had to call the police on this guy to get him out of there. He took his uncle in one time to the bank and said, we're going to redo this trust. My uncle wants to leave it all to me. I said, okay, you sit here. And he said, come with us, Mr. So-and-so. I said, do you really want to do that? And he said, heck no, I'm just scared of him. So they sent him on his way. Didn't change it. I got a call from a closing attorney one morning at the office. I said, Joe, this Mr. Jones, I'm not using Mr. Smith, by the way. I'll say Mr. Jones. This Mr. Jones has this, he's going to refinance his house, and I looked it up as the name of this trust. I see you were the notary on this, so I presume you wrote that trust. I said, yeah, you going to mortgage it? He said, yeah. I said, play hell. Not either. He's not going to mortgage it. The bank as trustee was not going to sign off on that loan. Frustrated there too. So the old guy came in and changed his trust to leave that kid out. The next kid did bad things, stole from him, took that kid out. The one we thought would be good with him, she ended up stealing one of his credit cards, having a good time with it, came in and left her out. Ended up everything being left to a special needs child that one of them had. It was actually probably going to be supported by the state for the rest of her life. But anyhow, all of those rascals were kept out of his life. He was able to stay in that dinky little house with around-the-clock care, pretty expensive. That's at least 10 grand a month. Didn't have to go to a nursing home where he otherwise would have gone. He spent the last of his days happy because of that, quote, gatekeeper trust. That's a real good use for a revocable trust. And I've used that often. Just did one last week, as a matter of fact. Yeah, stealing an inheritance. That brings me into that topic, stealing an inheritance. Did you notice when you turn 60, those of you that are 60 or more, this is most of us, not all of us. I see a few exceptions.
You're here, 62.
Yeah. I passed it a few years ago. I can remember when we turned 60, the phone would ring and the scammers were there. They knew by this time we were 60 and we started to show up on their radar. You know, they sell these mailing lists and phone lists and all that. We eventually just stopped our landline, like many people do, discontinued the landline because of all these calls. At least we can have some control with a cell phone. We sure wish we had that landline when we lose a cell phone, though. Where is it in the house? You can't call it. But if my wife is there, she can call from her phone and vice versa. But if you're by yourself, they have devices for that now, don't they? The phone will ring for you. I don't know how you get it. Anyhow, there's some sort of device you can have, not help with that, by the way. But these people start to show up. It's like sharks scenting blood in the water. It's fascinating to study, to read about some of these things. There are people that have actually studied the psychology of war to determine cute ways for the propaganda and so forth, to get control of somebody, to take over their personalities for them, and exert undue influence. A good example is a neighbor, a newfound best friend. Mom is alone. The kids, a couple of wonderful daughters live in another city. Can't see her that often. They call as often as they can. But this new friend shows up. May have just bought the house, by the way. If there's enough involved, they've been known to do that. I understand. I haven't seen it, but they will buy a place in the neighborhood or rent in the neighborhood. Show up, become very helpful, more and more helpful. Slip a $20 bill out on the table. Oh, Mabel, be careful with your money. You can't leave this out. The housekeeper might take this. Give it back to her. Earn her trust. Most honest person out there she's ever known. This wonderful person. And then, Mabel, I'm so sorry. What? Oh, I shouldn't have said that. I'm so sorry. Never mind. No, what? Come on, tell me. I can't believe your daughter said that. What did she say? And she makes up some horrible lie about something her daughter said. And this continues. Pretty soon, mom calls, good friend answers the phone. Your mom doesn't want to talk to you. The daughter calls mom. She doesn't want to talk to you. Sometimes the people will, especially if it's not a child, a friend or relative, come to the door. Mabel doesn't want to see you. Just isolates the person. Sort of, what's the term for capturing them in place like that? The technical term is not coming to me. But, and then of course there's a visit to an attorney's office. And the whole estate plan has changed. And guess who inherits? I had that happen to one client of mine 30 years ago maybe. She had a niece who had spent the summer with her in Shreveport. Every year, and then she had a hard life, but summers were wonderful for this little girl. Now she was a grown lady living in New York, had been a dancer and stuff like that. Her beloved aunt hired a caretaker, and some of her friends told me they would be there and she'd be stroking her head saying, "Oh, I love you, Mabel," and things like that. And they would call, "I'm sorry, she's not taking calls today. She doesn't want to talk. She's not feeling well. Come to the door. She doesn't want to see anybody." I had no idea she didn't want to see anybody. But when she died, a new will showed up, leaving everything to the housekeeper. That was litigated. The niece's husband was a New York lawyer who was not an easy guy to get along with, so I wouldn't represent her. Send him to another attorney. And they filed a lawsuit. I think it was actually settled, though. The niece didn't get the entire house. And it took many years to get that done. That happens all the time. Men are an especially easy mark if they're widowers. They get older, they get lonely, and they're still men, you know what I mean? Very interested in women, most of them. Like my retired judge example. One time he thought he had about 3 or 4 fiancées. They had no idea. He was hilarious. But that can happen. So in writing wills, it's important to have the ability. One of the nice things about having a trust like that is, let's say my wife dies first and her assets go in, her half of the assets go into the trust, where I am temporarily the trustee anyhow. And I start to go a little haywire in my old age, like 20 years from now.
Yeah.
That's a constantly receding time, old age. That's constantly receding. The date for that, the age. And let's say I start to get like that. May not be another woman, might just be I'm losing it. And they can't force their ways into my financial life. I could be at bats in the belfry. If I don't want them to see my bank accounts and so forth, they can't see it. But as the trust, even though they're not the trustee, they have a right to see what's going on. They have a right to see all the accounts and everything. If I don't let them, they can have me removed as trustee. Pretty simple thing to do. Might take a lawsuit, but it can be done. So that is protected. My wife is now protected, but with that type of a trust is protected my children from me, some future me that is not the real me. In fact, she told me Joe, you don't have to do that. I just want to leave it all to you. I said, but honey, let's protect the kids. She says, no, I just leave it to you. You can do what you do. I said, I'm not going to betray my children, maybe. No. Your will is going to say it goes into trust, just like mine does. I wouldn't be concerned so much about her remarrying. I think we've been married 53 years. I think she's had enough of that. But I would be concerned about her being too generous as she got older and started to become senile. Have friends who she'd want to just be so generous and nice to. That's the type of person she is. And she would be, people could take advantage of her in that sense. So we both need that trust. Me because I'm a guy, her because she's so generous. But you have to watch as people are, and this is a hard thing to do. I'm not an expert, not a medical person, but I am told that when people come down with various forms of dementia, just say Alzheimer's, one of the first things that goes is judgment. One of the last things to go is social skills before it really shows up. And I finally got to the point where when clients come in, sometimes I can sense which one is having problems. One of them is doing all the talking and asking questions, making eye contact. The other one not doing some of these things. But the kids that see them every day, or the wife or spouse that sees them every day, this stuff just creeps up. They don't realize, with the passage of time, how much difference there is. So sometimes they do, sometimes they don't. Somebody said, be sure to tell us stories about things. Yeah. I had some clients in, the kids brought their two parents in. I can picture them at the table. That's one thing I got a good memory for some strange reasons, where people sit. I have no idea why. Not perfect, but much better than my other memory. And the husband was here, the wife was there, one daughter was here, the other was there. You know, this has been like over 20 years ago. But they made an impact. They had a problem because the wife was getting involved in these sweepstakes. She kept buying sweepstakes tickets. And they were really upset because she was going through a significant amount of money. So they come in and talk about it. And the husband is sitting there just really criticizing her. And she's resisting and saying, no, this is true. She says, I have want some money. You want some money, Mom? Where is it? But I've got a coupon at home. Yeah, Mom. And finally the husband had enough. I mean, he was harassing her too, complaining, and she finally had enough to say, well, you and your stupid Canadian tax things. He said, well, that's different. And the kids, huh? They both had their blind spots. It was, if you put this stuff in a movie, nobody would believe it. You know? It was just astonishing. The kids, their mouths were literally open. It was, I mean, I'm laughing about it because of the comedy of it, but they were both wasting a lot of money and not doing anybody any good but some scoundrels out there. And so I forget what was done, but we took steps to put a stop to that, and they basically forced the parents to turn over the financial affairs to them. Forced them, I say, because the parents were willing to do it, because they were being harassed so much that they just gave up. Couldn't legally force them to do it without filing a petition to have them declared incompetent. And that's another strange thing about this. Sometimes the blind spots, the delusions, are in one particular area. Everything else is fine. Delusion will exist in one area, like happened with those two. One was delusional in one way. The husband could see absolutely that was a scam. She was very clear that his was a scam. So closely associated, you think scams are scams, but no. They had a blind spot for their particular scams they were falling for. Just mind-blowing. But I understand from psychologists, psychiatrists, that is not that uncommon, that people will be perfectly normal except for one thing, where they're not. Totally delusional. And I think it's even worse now with the internet, all this conspiracy stuff and so forth that goes around. So many things out there that are not true, but they sure sound true. I know I've been fooled a few times, so I looked into it and said, oh, that's a bunch of nonsense. This expert, she doesn't even have a medical degree. One of them, so-called medical guys out there spouting all this stuff, he's a computer scientist. He's not a medical guy at all. He just read about it. Those things can happen. We can all get caught up in that. But things to watch out for as you get older, as your family gets older, these things can happen. And that's why that article, Who Will Protect Your Children from You, was intended to make people think into the future. They have this special needs child. It means everything to them. They have a beautiful estate plan set up. Mom dies, dad gets older, develops dementia, maybe gets a girlfriend. Well, he forgets, he doesn't understand. Everything changes. Now this wonderful trust that was going to take care of their child for the rest of his life, the money's gone. Who is going to protect his child from him? Things to think about when you have nothing better to do. You call this doom and gloom. Yes, ma'am.
I have a question. If you have a trust that's set up in another state and you move to Louisiana, do you need to change it? Do you need to do anything with it? Or is it a trust just as a trust that travels with you?
Yeah, normally you don't need to do anything, but I always advise my clients when they move to another state to go ahead and get an attorney in that state, one who understands the materials, not just the average attorney. Now, I'm not trying to say we're some high and mighty attorneys that know everything about everything. You would not want to use me for a divorce or title insurance or anything like that. I don't do that, and it would be a mess. I've done one divorce and I regretted it ever since. For a secretary of mine, she was not happy. I didn't realize that she would change her mind all the time. Say, I'll do this. I go and tell the other attorney we're going to do that, and then next day, no, I want more. It was a disaster. It was a horrible thing to go through. No more divorce work. But it has to be somebody who specializes in the area. And a lot of estate planners, a lot of people that write a lot of wills are not really into asset protection planning, the use of trusts. One of the best attorneys I know, statewide reputation as an estate planner, especially for very wealthy clients. Very good in all this high-level estate tax planning. I got out of that 15 years ago because when they raised the exemption levels, all my clients, had very few clients that were that wealthy. It takes a tremendous amount of effort to stay up in that field, to be competent. So I gave it up, but this guy was still in it because he's with a big firm, they have big clients. He had a client whose daughter, in her 60s or 70s, was married to a fellow that had some strange form of dementia. And he's going to eventually need nursing home care if he doesn't die first. So he assumed that because this would be her separate property, it wouldn't be counted for Medicaid purposes if the husband had to go to the nursing home. He just did a will, leaving everything outright to the daughter, no trust. Medicaid counts it. The assets doesn't matter. Say you live in Kansas where they don't have community property. Assets of both spouses count for each one. Sometimes lead to a divorce, so they each stand on their own, but yeah. So, as great as he was, he didn't understand this little niche of asset protection planning that I call planning for the middle class, the working class, people like you and me. So, but sometimes when they come in, sometimes the trusts that were drafted really aren't accomplishing everything that people think they are. So we might have some suggestions for improvements. Sometimes they're just fine. Sometimes there's something about Louisiana law that's a little bit different, that needs to be an adjustment. But they're valid. Just may not do exactly what we want them to do. Powers of attorney are also good in every state. But as I say that, there was recently somebody, I think it was with a bank, these big banks especially, they're paying. Somebody said because the power of attorney was out of state, it wasn't valid in Louisiana. Total nonsense. The course it's valid in Louisiana. Valid in all 50 states, maybe even some foreign countries. But so what are you going to do, sue the bank? Just do a new power of attorney. Online documents. Sometimes they're okay. I'd never tell a client, just do something online. Some of the forms are surprisingly good, but none of them are fully adequate. And especially because you don't discuss the whole picture with somebody that knows what they're talking about. With most of my clients, we might spend 3, 4, 5 hours even together to make sure everything is covered, explaining things over and over again. For example, if I were to pass out some little quiz sheets right now, how well would you do on the test for what we've run through today? If you do well, you'd make me feel mentally inferior, I'll tell you that. Because I know I wouldn't if I were in your shoes, the roles were reversed. Or you gave me some lecture about how to do rental properties, all these little things you have to know. It'd soon be coming in this ear and going out that ear. It takes time for this stuff to soak in.
Right.
So we spend a lot of time with our clients to make sure it's getting done what they need to have done and what they want to have done. They're the client. We just make sure they understand it as well as we can get them to, and they make the decision. We don't tell them you need to do this, you need to do that. Here are the options. You're the client. You're a grown man. You tell us what you want. Just want to make sure you understand what it is. Doesn't have to be the way I do it, that's for sure.
Question,
Yes, sir.
if we already have a trust, how often should it be reviewed over time?
It depends on what kind of trust it is. And,
Irrevocable trust.
okay,
All of our assets are in it,
okay. Who are the beneficiaries?
our children.
Okay. Now thank you. That's one thing I forgot to cover. And a lot of this planning, what we end up doing, like I told you how a little bit of the LLCs were given to the children. What I recommend my clients do, we use this a lot for Medicaid purposes too, if we're going to do gifting as part of the plan, give a lot of money to the kids. If you just give a bunch of money to your kids, thinking they're going to hold it and help you out when you're in the nursing home, because Medicaid doesn't pay for everything. What if they get sued? What if one dies? What if they go loopy? They get confused, think it's their money. What if they weren't as nice as you thought they were? Things like that can happen. So I like them to put the money, the LLC shares, whatever it is, into a trust, an irrevocable trust like you got, with the children as the beneficiary. Now that money, whatever assets you put into there, if it's drafted properly, is gone as far as creditors are concerned. They can't get into it because it's not yours. So if you had that car wreck I keep putting everybody in, the big $10 million judgment, that's not your money. Now if you give it away after you had the accident, they can chase it down. But if you've already given it away like you have, the whole 10 million, creditors can't go into that trust and get it if you have a liability. If your kids have a liability, if it's drafted properly, the creditors can't get it from them because they didn't put it in, you put it in. It wasn't their money, it was yours. You tied it up with strings attached in this trust document. Now sometimes we get clients who have irrevocable trusts that need to be changed for some reason or another. And they can be done with a court judgment. We have to go to court to get it done. So we can get some things changed. Early in my career, when I was attracting a lot of younger clients back in those days, really close to 40 years ago. Probably stopped getting young clients about 15 years ago. They want a young lawyer who would be alive as they age. So I don't blame them for that. That was more short-term stuff. I still get a lot of doctors and so forth, but they're not the real young ones, with a few exceptions. One of the things we ask is, okay, now presuming you both die, how old and everything goes in the trust for the kids, how old do you want the kids to be before they get their money? I say, oh, I don't know, what do you think? I say, well, a lot of people say 1/3 at age 25, 1/3 at 31, 1/3 at age 35. Yeah, that's not a good idea to do it that way. I realized a few years later, that's not a good idea. Why are we doing that? Why are we saying that trust terminates so the kids lose all this marvelous protection? After all, they can have an accident after they're 35. They can go to, if they still have that money when they're 70, and go to a nursing home, and it counts for Medicaid purposes. So I now take the ages out. If you want the kids to be able to get the money at age 25, let them be the trustees at age 25. Then they can do what they want to with it, but the trust is still there. It's theirs. They're in charge of the trust. They can get it anytime they want to. Like to make it like a cookie jar. It's up in the cabinet where the kids know where it is. They can go get it and get cookies anytime they want to, but somebody else comes along to get those cookies, they can't get them. They don't know where they are. Because they know what the trust is, but they don't have the ability to get it. But the kids can. That's called a beneficiary-controlled trust. Not a legal term, just we get trust a lot of names depending on what concept with the trust, what attribute we're talking about. That's beneficiary control. The kids control it. Most of the trusts I draft, at least 2 of the kids, maybe 1, if there's only 1 good kid in the bunch, 1 trustworthy one, or they start off as trustees. A lot of times the parents start off as a trustee. If it's an inter vivos trust, the parents will be trustees often to start with, and that's fine. Because I once had a trust for one of my sons, and didn't have a lot of money in it, but I was a trustee. I wrote him a check one day, and that was the end of that trust. That was the end of that money too. Like I say, it wasn't much. He was a young guy. His knees were great. He was secretly married. I didn't know. Yes, ma'am.
I have a question with regard to homes that we have inside our IRAs. Tell me about how protected they are.
Okay. Those are protected, and you have a trustee?
Yeah,
Yeah.
equity trust.
Yeah.
And they're the custodian of the.
Yes. Yeah. Those IRAs are protected from creditors, except Medicaid. Not protected from Medicaid. Most states count IRAs. All states, I do, I think. It used to be Louisiana would not count the IRA for the spouse who was not in the nursing home. They left that out, but they changed the law, changed their manual about 15, 20 years ago to where that counted against both spouses. So it's very high level of protection with an IRA. The only person you're not protected from is IRS and Medicaid. Medicaid, that can't seize anything in that IRA. They just won't pay the nursing home.
So as an example, if I have a rental property inside my IRA and the tenant sues me because they fell and whatever, so they can't get anything out of the IRA. Is that what you're saying?
I never thought of that before. The IRA is the owner of that, well, it's in a trust. IRA, the house itself is in a trust.
Correct.
So they might be able to get into that little trust even though it's within an IRA. I don't know. That's a very interesting legal question. I never thought of it.
Do you long-term care insurance, do you recommend that, or?
Yeah, long-term care insurance. It's a very interesting thing. I have some clients that bought their policies long ago, like 20, 25 years ago. Really good deals. The insurance company, a lot of them that went into this lost tons of money because they did not realize how life expectancies were going to be stretched, but not wellness. So their actuaries really got that all screwed up and they lost a lot of money. So their rates began to just skyrocket. And now, most of the time that I see somebody buy long-term care insurance, they buy what's basically a combination of an annuity or life insurance and an IRA. And the insurance, the long-term care insurance. Say somebody puts $100,000 into it. It will pay. If you die never having used it, you get your $100,000 back. If you have to go into a nursing home, it will keep paying, keep paying. Let's say your nursing home fee is $200. It'll pay the $200. It'll eat up the $100 and keep paying. Probably $50,000 is a better figure to work with, more realistic. But so that's the type usually that people have. It's a sort of a lump sum investment, as opposed to you just paying a monthly fee, because they're so expensive now. Back when every audience is unique. Yes, sir.
Earlier you were talking about you had multiple rental properties. You know, what would be your recommendation? You have to say 10 rental properties or 20 rental properties. Would you divide them up in half in 2 different LLCs, or maybe 4 different LLCs? What would you do?
Yeah, it's totally up to you. Okay, one lady told me she's going to have to do all the bookkeeping on them all anyhow. She keeps separate records for each one of them. So she wanted to separate each one to make sure that if one went bad, it didn't steal anything else. She didn't lose anything else within that LLC. Some people say, I don't want to mess with that many LLCs, don't want to pay the fees, all that sort of stuff. I think it's only, what is it, $75 a year? Something like that. Yeah, so it's not much, but to have it done right, in my opinion, and I admit I do have self-interest in saying this, I think it ought to be done by, ought to be drafted by an attorney. You can get all these forms and stuff, but I see a lot of them come in, don't even have something that we call an operating agreement.
Pay a lawyer for the first one and I copied it for the second.
Yeah, yeah. Well, I'm sure a lot of my clients have done that too, which is to be expected, yeah.
It's the same documents are changing it.
Yeah.
Question.
Yes.
Did you speak on a charging order, LLC?
Yes.
States have them. I want to say Wyoming, maybe Delaware.
Yeah.
Nevada.
Every state has a charging order. That's they may not call it. In fact, Louisiana does not use that terminology, charging order. I know in California they do, and other states. At one point in time, the main focus of my planning was asset protection planning for bankruptcy and things like that. I had several years of bankruptcy experience, and a lot of wealthy clients wanted to protect their assets, and I was deeply involved in that. And charging orders is the only thing you get against. Now, partnerships are not as strong as LLCs. I know in California there were at least 2 partnerships years ago. The court dissolved them, so the creditors got their money. They dissolved them because nothing else was working. They said, try this, try that. The creditors went through all these steps to try to get their money. Nothing worked because of the protection of the partnership statutes. So the court finally said, okay, you can dissolve, creditor, you can dissolve that partnership. Can't do it with an LLC if it's drafted right.
Did you define what a charging order is and what it does?
A charging order is ruled by the judgment by the judge. It says, Mr. LLC member, if you get any money from that LLC, you have to turn it over to your creditor. Actually, it has to be paid from the LLC directly to the creditor. The LLC is charged or ordered, charging order, to pay money to the creditor instead of the member. Okay? Other questions? I enjoyed talking to you. This is a very nice group. Thank you.
Thank you so much, Mr. Gilsoul, for coming.
Thank you. My pleasure.
It's a wonderful speech, and I took plenty of notes.
Thank you.
I think this concludes our meeting for tonight, and we'll see all the members next month. Have a good evening, everybody.